Welcome back to Jane Hawtin Live.
This is Jane Hawtin Live. Our guests tonight are Wendy Carroll and her husband Shore Tronson, who are suing the federal government after Wendy was attacked by two convicted murderers who were freed by the parole system. Joining us is Tim Danson, the lawyer who is representing them in the civil suit. Nice to see you, Tim.
Good to see you.
We actually didn't get to that part, that you are suing the government because of the fact that you were attacked by these guys who were on parole. Is something like this going to work?
Well, I hope so. I mean, the problem that we've had in cases like this and many other victims' cases is that the government will say, well, the system failed, but there's no individual who is responsible and there's no accountability. And as long as government officials, parole officials, correctional officials are not held accountable, if they feel they don't owe a duty of care to the public at large, these kinds of tragedies are going to happen again in the future. I mean, Wendy, it was an attempt murder. I mean, if people look carefully at the medical evidence, it's just, but for the grace of God, wasn't a murder. Yeah. Not just because of the loss of blood, but because the medical evidence shows that it was only a miracle that the knife, as it went 9 millimeters into her neck, didn't hit major arteries and other nerves. And quite frankly, it would take a surgeon to be able to get it in there without hitting those arteries. And that's how much of a fluke this was. And in this particular case, I think it's not just that these two fellows have two previous convictions for double murders, but that they were in breach of their parole, that warrants had gone out, or that they had been, their parole had been suspended. In Keogh's case, he had been at large for 4 months. In Schwartz's case, it had been some 7 months. And nothing was done until this crime took place. And
so that's how they found them, right?
That's right. Yeah. So the point of it is, in this case and many other cases that I've been involved in, that these people would have remained at large until such time that an offense took place. And the circumstances of this case was that they got caught for the offense. There are other situations where people are at large, they commit offenses, and we don't even know they've committed it until quite some time later.
Right.
So the purpose of the lawsuit is to find out exactly what went wrong, why they were out on parole, why they weren't arrested. And really, the public, Wendy just happened to be the one they chose. It could have been anybody.
Right. But the issue is public safety here. I mean, Absolutely. We're not supposed to be paroling people who are going to continue to be a danger to society, right? Isn't that the idea?
That's right.
Or even if we are, we're supposed to be monitoring them.
Right. Keeping track of them.
That's right. Well, see, what's remarkable here, and now that the criminal proceedings are over and we're going to go, full speed on the civil side and get more information and production from the government, is that their view is that once they suspended their parole, and they were at large, that the correctional officials and the parole officers felt that it was out of their hands. They had no other further responsibility. One of the things that I'm going to be looking at in the civil case is to see how the parole officer communicated to the police that these people were at large. Did they communicate to the police, oh, by the way, they're not just in violation of their parole, but these two fellows have committed double murders each, and they represent a danger.
We got to find them.
Well, in my opinion, what should be their picture for when double murderers are in breach of their parole and they're at large. My view is that their picture should be on the front page of every newspaper and every broadcast in the country, so people are made alert that these very dangerous people are at large and that they're at risk. To do nothing, which looks like what happened here, until there's another tragedy, is unacceptable, and I think these people have to be held accountable, and that's what the lawsuit's all about.
Okay,
go ahead. I was just going to say, I think it's very unacceptable to us to find this out, that there is no accountability put in place. There's no system, there's no stream, and so for the government to feign and say, we're not responsible, or no one individual has been responsible, then what is the system in place to handle this?
Well, this is something that we've been, hassling over for quite a few years, though. I mean, because the whole issue of personal accountability, which is what you're talking about here, holding parole officers or their system or whatever responsible, is not something that's happened.
Well, it's what we're pursuing, and often in these cases, when they get close to trial, the government has a way of settling them and signing the clients up to confidentiality agreements. But be that as it may, I think it's interesting in this case, not uncommon to other cases. In their statement of defense, the government pleads that they owed no duty of care to Wendy. So when they say they did not owe a duty of care to Wendy, they're saying they don't owe a duty of care to any member of the Canadian public. And further, they say that even if we did owe a duty of care, which they deny, they claim that they perform their duties in a very faithful and diligent and prudent manner, and that in any event, even if they didn't, in the alternative, they say there's no nexus between these two people being in breach of their parole and at large and the attack on Wendy. A rather remarkable
They're not
proposition.
connected.
Not connected at all.
It's not reasonably foreseeable, as
All right.
the legal
We'll come back to
argument
this issue, but I want to come to the topic that we're talking about, and that's the topic about what the jury should get to know and not get to know. Why didn't the jury in this case get to know that both of these characters were convicted double murderers?
The short answer to that is a Supreme Court of Canada decision called Corbett, where the court held that the prejudicial effect of a juror knowing, if we use this as an example, that these two people were had been convicted of double murders prior to, that the prejudicial effect of that is so severe that it outweighs the probative value. What the court was concerned of is that clearly, and this is essential to our justice system, the Crown must prove every constituent element of the offense beyond a reasonable doubt. And I don't think anyone at this table or any victim that I know of would think that that test should ever be compromised.
No.
What the Supreme Court of Canada was concerned is that if the jury knew that they had been previously convicted of double murders, their focus would be on that, and that unintentionally the Crown won't be proving its case beyond a reasonable doubt because the prejudicial effect of that knowledge will convict them rather than the merits of that particular case. That's the
But what about the issue of
reasoning.
character? I mean, doesn't this go to character? If you know that,
Well,
if you're wondering about these guys' character and whether they were
Right.
so stupid that they wouldn't kill anyone as they
Right,
were arguing
Well,
in
like
court.
Tim said before, it's only a certain kind of person that can kill your own children.
Right.
I mean,
but-
that's relevant information.
We have to put this in context. In the Corbett case, it so happened that the court ruled in favor of a murder conviction being put to the jury. So if you put your character in issue, then that goes out the window. And one of the things that was disturbing in this particular case after the Corbett ruling, which I'm not saying was wrong, I think the ruling was that the jury knew they were out on parole for serious criminal offenses.
yeah.
I think they should have been aware that they were out on parole for serious violent offenses. But
Right.
be that as it may, as soon as Keogh, for example, takes the witness stand and through his counsel and through himself is telling the jury that he's a good father and he loves his child, at that point it's absolutely wrong for the jury then not to be told, oh, by the way, or that
He
the
killed
Crown,
his two
he
children.
killed his two children, because then you're misleading the jury. So you may start off with the prejudice, and a good defense lawyer who works with his client will know when not to cross that line. In the closing address to the jury, one of the defense lawyers said to the jury, effectively criticizing the Crown for not cross-examining the accused on the question of whether or not they would, or not suggesting that they would kill for the thrill of it or for the fun of it. Now, that, in fact, could have created a mistrial, and if the Crown didn't want a mistrial, but had they not been convicted, it would have been a very strong appeal point, and there would have been a new trial, because you would have then prejudiced the jury. So there's a balance that has to go on. A lot of common sense. I don't think the problem is the Corbett decision. It's the application of the principles.
Okay, so we don't need to change a law. We've got the law there that lets judges have this information to juries. But let's go to the phone lines and talk to Lou, who's calling from Toronto. Hi, Lou.
Hi.
Hi. What's your reaction to this?
Well, I think that in Canada, it's a two-tier system as far as provincial and federal law goes.
Yep.
And in this particular case, though they were both federal offenses, which would have put them down in penitentiary, you have to understand that the Crown doesn't look at it that way at first. The Crown will look at it as a two-tier system and will go for what the Crown believes it can get. You know, like a fisherman won't necessarily go for the biggest fish. He'll get the fish that he can feed his family with, and that's probably what the Crown went for here.
What do you mean?
I feel very sorry for the lady that got stabbed, because I think that was an unnecessary part of her life. But for these gentlemen, they're lawyers being fish themselves, sharks, so to speak. No offense to the man I'm looking at on the TV, though. But they go for what they can get, and that is to get their clients off with the less serious charges that they can reach.
Right. But what about this issue? Do you think the jury should have been told that they were convicted double murderers?
Okay, well, as a person that's been convicted of crimes and done prison time, yes, I do agree with it. Because if I go back and do crimes that I've done in the past, then they can't be brought to bear against me. As I told the woman I was talking to before I talked to you, said to her that if I'm just going to get a slap on the wrist for doing something that I've already done before, what's the use of having a trial for me? Because then I know if I'm just going to go back out onto the street again the next time and go do what I did before and be told by my lawyer, don't even worry about it, you'll just get another 6 months or a year or 2 years for what you did, though you've already gotten 6 months, 2 years, a year. I mean, if you look at the newspaper, how many times do you see in the paper somebody has 126 convictions against them or 80 convictions against them?
Yeah.
You know, and yet they will get maybe 6, 7 months at a time.
Right.
You know, that's not right. And it's not fair to this lady here because she knows that at some point in the future these two gentlemen, you know, I've used the term very loosely, can come back out and hurt her again. Yeah. Or hurt somebody that, you know, maybe she doesn't know her, but somebody again, and she would know at that point, hey, these two idiots got out again, and they couldn't be brought to bear on that trial again.
Okay, thanks for calling, Lou. And, you know, I guess I also go to the jury. I mean, and how annoyed, how abused do jurors feel when they, you know, if they've anguished over making a decision like this, and then to find out afterwards that this is pretty key information that they've been denied.
I would think that a majority of Canadians, and perhaps more appropriately a majority of jurors who have sat on juries in the past, would probably say, look, if we're given the responsibility to determine innocent and guilt and listen to directions from the trial judge as to the law and for us to make complex decisions on the facts or what have you, that they'll probably say that we're intelligent enough to make a distinction on, notwithstanding their criminal background. I think a juror would say, we want all the information we can have in this case as possible, and let the trial judge give us directions as to the law as to how we use that. If we can't trust jurors on that, can we trust them for the ultimate decision on innocent or guilt? And I think, I'm just saying, I may be wrong, but I think many jurors and Canadians would probably think that if they're going to sit on the jury, they have the right to this information and let the trial judge give them the direction on the law as to how to use it.
Well, we spoke immediately after the verdict was handed out, and we said, can you imagine what the jurors would feel if they had rendered a different decision and they had just been told this information? Even from our point of view, which is obviously prejudicial, we were horrified for them. Right. But by seeing their faces when the judge read out the sentencing, we knew.
You know, so sure, before we let you go, how hard has this been to go through all of this process? I mean, obviously the process of the stabbing was horrendous, but then the trial as well.
I think from all aspects, I mean, I'm so grateful that my wife is beside me here today. So, I mean, that's part of our healing process is taking up the fight for future victims and those that don't have a voice. But the actual incident and when it happened, it was the most terrifying thing I can ever explain. It is the exact same process as losing somebody. However, you know, through the miracle of the situation, Wendy is here today. But I met with the priest when I got to the hospital. I didn't meet with the medical staff, so it was terrifying.
Okay, thank you for joining us.
Thank you.
Shore Thornton is Wendy Carroll's husband. When we come back, we'll meet a criminal defense attorney who says telling the jury about past crimes is extremely prejudicial. We want to know what you think about this. The phone lines are open at 1-800-510-JANE, or you can email us at jane@electric-tv.com. You're with Jane Hawtin Live.